Welcome to the webinar entitled 2013 Healthcare Fraud and Abuse Bootcamp Webinar Series, Part 6, Trends in Government Enforcement. This Bootcamp webinar series is brought to you by the Fraud and Abuse Practice Group and is co-sponsored by the Healthcare Liability and Litigation, Hospitals and Health Systems, In-House Counsel, Labor and Employment, Long-Term Care, Senior Housing, In-Home Care and Rehabilitation, Life Sciences, Medical Staff, Credentialing and Peer Review, Payers, Plans and Managed Care, Physician Organizations, Regulation, Accreditation and Payment, and Teaching Hospitals and Academic Medical Centers Practice Groups. I would now like to introduce today's moderator, Kevin Raphael. Kevin?
Yes, good afternoon. I'll be serving as your moderator today. Thank you for joining us for today's presentation, Trends in Government Enforcement. I would also like to thank our distinguished panelists for their time this afternoon. The panel today will be speaking about the following 5 topics, which I'll be displaying on the PowerPoint. Before we begin, please let me take a moment to introduce everyone. Our first panelist is Tony Maida. He is the Deputy Chief of the Administrative and Civil Remedies Branch of the Office of Counsel to the Inspector General, U.S. Department of Health and Human Services. Tony represents the OIG in a wide range of healthcare fraud and compliance matters, including False Claims Act and civil monetary penalty law cases, exclusion appeals, and the negotiation of corporate integrity agreements. Tony oversees ACRB's casework and policies concerning enforcement of the federal anti-kickback statute and the physician self-referral law. He is a frequent speaker at American Health Lawyers Association and American Bar Association conferences and law enforcement training programs. In 2011, Tony received the OIG's Bronze Medal for Outstanding Employee of the Year. Tony graduated cum laude from Boston University School of Law and magna cum laude from Fordham University. Our next speaker is Bob Rode, who is a partner at Crowell & Mooring in Washington, D.C. He is a member of the firm's government contracts and healthcare practice groups and co-chairs the firm's False Claims Act and healthcare litigation practices. Bob defends companies and corporate executives facing criminal and or civil government enforcement actions under the Federal False Claims Act, including the Ketam whistleblower actions, state false claims laws, and other fraud and abuse provisions. Prior to joining Crowell & Mooring in 2007, Bob spent 9 years at a national law firm where he led its False Claims Act and healthcare litigation practices. Prior to that, Bob served for nearly 6 years as a government attorney with the Navy Judge Advocate General's Corps. For the past 10 years, he taught as an adjunct professor at the George Washington University Law School, and he currently serves as the co-chair of the ABA Health Law Section's Ethics and Professionalism Committee and the vice chair of the eSource Editorial Board. Our last panelist today is Linda Wazinski. She is a Deputy Chief of the Chicago U.S. Attorney's Office's Civil Division, and she serves as the Civil Health Care Fraud Coordinator for that office. During her decades of government service, Linda has handled a variety of significant health care fraud cases involving individual and corporate defendants, recovering hundreds of millions of dollars under the Federal False Claims Act. Linda has made presentations to various organizations on healthcare fraud issues, including the American Hospital Association, the American Bar Association, the Healthcare Compliance Association, the National Healthcare Anti-Fraud Association, the National Conference on Healthcare Compliance, and the American Health Lawyers Association. I am a partner of the Philadelphia firm Petrogallo Gordon, Alfano, Bostic, and Responti, and serve as a chair of the Healthcare Practice Group. I have handled a wide variety of white-collar cases across the country, including healthcare fraud, Medicare and Medicaid fraud, Food and Drug Administration, criminal investigations, and public corruption cases. I also represent healthcare entities in civil litigation such as the defense of RICO and civil fraud cases, overpayment, billing, and reimbursement disputes, RAC disputes, Medicare appeals, and licensing board and credentialing committee actions. I would like to pass the presentation first to Bob, who will be discussing enforcement actions against individuals, criminal, civil, and administrative exclusions. Bob?
Great. Thank you so much, Kevin. And I'd like to just jump right in. As Kevin said, we'll be covering enforcement actions against individuals, which will include the different types of tools that the government has and is using and what the trend lines are for its enforcement efforts as to individuals. And the reason this is important is because historically, the government's healthcare fraud and abuse efforts have been focused on entities, providers, payers, pharmaceutical and device manufacturers. But the times, as they say, are changing, and what we've seen is a growing trend towards the government focusing on individuals. And the reason for that is a growing frustration. In this slide, this is a quote from HHS Deputy Inspector General for Investigations. And basically he says, today what is most troubling to HHS OIG is the possibility that some unethical healthcare corporations build the cost of paying civil fines and penalties and implementing CIAs into their cost of doing business. Some hospital systems, pharmaceutical manufacturers, and others play such a critical role in the care delivery system that they may believe that they're too big to fire, and thus OIG would never exclude them. And then he goes on to say, and again, this is Gerald Roy, as long as the profits from fraud outweigh those costs, abusive corporate behavior is likely to continue. And importantly, he ends with, when there is evidence that an executive knew or should have known of the underlying criminal misconduct of the organization, OIG will operate with a presumption in favor of the exclusion of that executive. So why is this important? This is, I think, one of many quotes I could have chosen that expresses what is a growing frustration with leadership at DOJ and the agencies about the lack of a deterrent effect that some of their enforcement actions against entities have had. And if you look at it in the context of, let's say, the pharmaceutical industry, we oftentimes see settlements reported that are in the hundreds of millions of dollars, yet the frequency in which those settlements are reported or the types of conduct at issue haven't seemed to change much over the course of the last 5 years or so. And I suppose that if you are an executive of a company and there's some conduct that's potentially improper but has the potential to allow you to reap windfall profits, and you know that the fine you might have to pay
Please forgive us for one moment. It appears we're having some technical difficulty with the sound system for Bob's sound system. We're working on it, and we'll get back to you in one moment.
Well, hello, everyone. This is Tony Maida. I think this technical problem might just be limited to Bob, so why don't I jump in, too, since he was talking about OIG-related issues, because I think that what Bob was saying is very true from the government's perspective, is that there is increasingly a concern that corporations are internalizing the potential for the cost-benefit analysis of potentially getting caught and having to pay a fine with the profitability of their business model. And it is increasingly, I think, a concern on the part of the government, and also the recognition of the fact that corporations don't act on their own. They act through the individuals who run them. And so we are, as the enforcement agency, increasingly looking to hold the individuals accountable who have engaged in the conduct. And I think that that both DOJ and OIG share that goal.
Tony, I think that's absolutely true, and what Bob was saying about the issues.
Hi. This is Bob Road. I apologize. Our entire building in Washington just lost its power, which is why I dropped off. And my headset also doesn't work, so I have a handset now. I can't.
Well, welcome back, Bob.
Well, thank you. I can't see anything on my screen. I can continue to go through the slides if somebody will advance them for me.
Sure, I can do that.
Okay. Thank you. So
I was just agreeing with everything you said from the government's perspective, and I think that, and so then we could move to the responsible corporate officer doctrine as one example of how individuals can be held accountable under that, at least that one legal theory.
Sure. So if you can move to slide 6, I think I can pick it up.
Sure. Yep, we're there.
Okay, so historically, the responsible corporate officer doctrine, as Tony said, it's something that the government has used in the past, and I think will use with more and more frequency to go after individuals. When I was in the Navy, we used to have something called the captain of the ship doctrine, which was basically that ultimately the captain of the ship is ultimately responsible regardless of what happens. So if a ship runs aground, even if it's in the middle of the night and the captain's asleep in his stateroom, it's not the junior officer who's steering the ship that's to blame. Ultimately, it's the captain. And in essence, that's the principle which underlies the responsible corporate officer doctrine. And it's been primarily brought in cases under the Food, Drug, and Cosmetic Act, and it's also been used to enforce strict liability laws affecting health and safety, such as environmental cases. It was first announced in the Supreme Court case of the United States v. Dodderwood, and in that case, it involved a misdemeanor conviction for a drug company's president, even though he had no knowledge of the unlawful conduct, and they found guilt solely on the basis of his authority and responsibility as president. The majority reasoned that the balance of relative hardships in that mix, it's still better to penalize the responsible corporate officer because they're the only ones that are in a position to be able to do something. And if something bad happens that could have been prevented, they should hold the executive liable, particularly when the public who's at risk is wholly helpless. The dissent in that case said, we strongly object based on the fact that this violates the fundamental principle that guilt is personal and you can't impose guilt on somebody unless they have actual mens rea or an intent to do wrong. So if you can advance to slide 7.
Yep.
And then, and again, that the Dodderwood case was from 1942, and then it fell into disuse, and then it was revisited by the Supreme Court in United States v. Park. And thus the responsible corporate officer doctrine is also sometimes referred to as the Park doctrine. And in that case, the court upheld a misdemeanor conviction of the president of a food chain whose warehouses were rat-infested, even though he had delegated the responsibility to keep control and care of the warehouses to others and had no knowledge. And what the court said when they were describing the responsible corporate officer's duty was, quote, a positive duty to seek out and remedy violations when they occur, but also and primarily a duty to implement measures that will ensure that violations will not occur. And the court goes on to express that, yes, this imposes some burdens and hardships on executives, but again, they're the ones that are in the best position in place to be able to do something about it. The doctrine, the Park doctrine or RCO doctrine, fell into a period of disuse and really was only invoked in cases where the individual either participated in or actually knew of the wrongful conduct. So it's a deviation from the purest sense of it, the captain of the ship sense, where simply by virtue of someone's position they should be found liable. What the cases started to suggest is that there needs to be some act or omission by the individual. And it was following a March 2002 letter from the FDA Commissioner Margaret Hamburg to Senator Grassley that suggested there would be a resurgence in responsible corporate officer doctrine in prosecutions, and there has. In her letter, she stated that the FDA had determined to, quote, increase the appropriate use of misdemeanor prosecutions, a valuable enforcement tool to hold responsible officers accountable. And she also expressed that criteria had been established as to what should be considered in determining whether to use misdemeanor prosecutions under the responsible corporate officer doctrine. And since then, the FDA has updated its regulatory procedures manual to include the criteria, which basically states that when the FDA is considering to recommend a misdemeanor prosecution, they should consider the individual's position in the company, the relationship to the violation, whether the official had the authority to correct or prevent the violation, knowledge of and actual participation in the violation are not prerequisite to a misdemeanor prosecution, but are factors that may be relevant, etc. And what that suggests is that it's a version of the responsible corporate officer doctrine that kind of reflects what the cases after Park showed, which that more often than not, there should be some level of act or omission by the responsible corporate officer. So if you could move to slide 8.
Okay.
Okay, and one of the other individual enforcement tools the government has is something known as honest services fraud. And basically, what honest services fraud refers to is a 28-word sentence of 18 U.S.C. 1346, which is the federal mail and wire fraud statute. It states that for the purposes of this chapter, the term scheme or artifice to defraud includes a scheme or artifice to deprive another of the intangible right of honest services. And if you can move to the next slide, slide 9.
Yes.
Okay, and the statute has been applied by federal prosecutors in cases of public corruption, also in cases of allegations of a breach of a fiduciary duty to another. In the former, courts notably have been divided on the question of whether there needs to be a state law violation for an honest services fraud allegation to stick. In the latter, when we're talking about a breach of fiduciary duty, courts have taken differing approaches to determine whether they've committed honest services fraud and whether there was reasonably foreseeable economic harm. But the case that most people know about, and the case that has actually articulated what honest services fraud is and is not, is the Skilling case. Involving former Enron executive Jeffrey Skilling. That case made it all the way to the Supreme Court, and in June of 2010, the court ruled that the statute was drafted with unconstitutional vagueness and, quote, henceforth will only cover fraudulent schemes to deprive another of honest services through bribes or kickbacks supplied by a third party who has not been deceived. Close quote. Now, the impact of what this means is still unclear. At first, folks were thinking that the circuit courts would revisit honest services convictions of individuals and reverse those convictions, and that really hasn't happened. What most circuit courts have done has found that while the instructions may have been in error to some extent, they were not harmful enough to be reversible. So, in essence, what's happened is a lot of the misdemeanor convictions and convictions for honest services fraud have been upheld even in spite of Skilling. But the one thing we can learn from Skilling is that, in order for there to be a conviction, there needs as a predicate to be a finding of kickbacks or bribes. But what the decision doesn't do is it doesn't tell us what the contours are of bribery and kickbacks. And so, there's still an open question as to what the level of evidence would be that would suffice for a bribe or a kickback to warrant an honest services fraud conviction. you can move to the next slide. I think that's...
Yes.
Are we on slide 10?
Yep.
Okay. And I'm going to try to get through this relatively quickly, but one of the other big areas, other than the Park doctrine, the responsible corporate officer doctrine, honest services fraud, there's an array of tools that the government has. So it has criminal, it has civil, and we'll be talking about the False Claims Act in a moment. And then it also has exclusionary authority, which it exercises at the agency level. And Robin Schneider, a senior counsel, or at least was, in the OIG's Administrative and Civil Remedies branch, was quoted as saying, "Exclusions are remedial in nature, not punitive. They are a payment-related sanction, and if excluded, no payment may be made for any items or services billed to a federal health care program." And there's two types of exclusions. There's mandatory exclusions under 42 U.S.C. 1320A, 7A, and there are four bases for a mandatory exclusion: conviction of a program-related crime, conviction relating to patient abuse, felony conviction relating to healthcare fraud, and felony conviction relating to controlled substances. And then in addition to the mandatory exclusionary authority, there's also permissive exclusion authority that the agency has. And they list out 16 enumerated reasons ranging from misdemeanor convictions for fraud to conduct that would warrant imposition of a civil monetary payment or a CMP. And I'll defer to the statute, but they're all listed there. And if you can move forward to slide 11.
The new B16?
Yes. And so Section 6402D1 of the Affordable Care Act added to the OIG's permissive exclusion authority by adding the new subsection B16. And basically it relates to false statements and enrollment documentation. And it permits the OIG to exclude any individual or entity that made any false statement, omission, or misrepresentation of a material fact in any application, agreement, bid, or contract to participate or enroll as a provider of services or supplier under a federal care program. And that includes Medicare Advantage, Medicare prescription drug plan sponsors, Medicaid care organizations, and entities that apply to participate as provider of services. And I think that's very important because I've already in my practice have seen instances where the government has been pursuing that type of conduct where their focus, whether it's under the False Claims Act, whether it's an exercise of exclusionary authority, are really looking hard at plans now, particularly those that participate in Medicare Advantage. And Tony, I don't know what if you have any thoughts or views on how that exclusionary authority has been exercised and is being used on a practical level.
I think that I think that it's something that's going to come up more often. It certainly is a helpful tool in the ACA, sort of fills an enforcement hole that we had in the false statement context. So I think it is something that we're going to see more of in the future as, conduct falls within this is, within the statute, covered by the statute. I did want to follow up a little bit, too, on your discussion of the RCO doctrine and OIG's exclusion authorities, because I think just to add a couple of examples of how OIG's particularly permissive exclusion authority can be implicated by some of these cases. Many people may be aware of the Friedman decision.
The Purdue
Pharma executives who, in fact, pled guilty to misdemeanor misbranding under the RCO doctrine and were subsequently excluded by OIG under a permissive authority under B1, which is a misdemeanor relating to fraud. And it was actually a significantly litigated case. It went up through the D.C. Circuit Court of Appeals, and the OIG won in terms of the courts all agreeing that we had the basis to exclude those executives based on their plea under the RCO doctrine. And it is a good example of that sort of cost-benefit tension that the government is finding, because in the conduct involving Purdue, it was a substantial settlement. It was a $600 million settlement. The sales for OxyContin, which was the drug at issue during the time period, was $2.8 billion in sales during the covered conduct. So I think it is an example of where the government looked at the conduct and decided that there was the evidence that there was a need to pursue the individuals who were responsible, who the government believed was responsible, and ultimately those individuals pled guilty to misdemeanor misbranding.
And there, if I recall, the exclusion period was 12 years, and that was challenged. And I believe the D.C. Circuit said, well, gee, that is probably a bit arbitrary and capricious, or we at least need to know the basis for the 12 years, but we're going to find that 12 years is too long, and they sent it back down. Is that correct?
Well, right. That's almost totally there. They didn't actually say that the 12 years was too long. They said that it needed to be remanded for the department, for the DAB, to provide a sufficient justification for the term. So they left open the possibility that 12 years was the right number, but they found that the DAB's decision was lacking in terms of its explanation and remanded back for that. At that point, after over 5 years of litigation, the parties did settle, so we're not going to have additional litigation on that point. But that is how that ended up in terms of the term.
Okay. And if you can advance to the next slide, and we're a bit behind because of my power outage, but I'm going to try to just get through it quickly. So slide 12, please.
Yes.
So slide 12 addresses the new exclusionary authority under the Affordable Care Act, and it has to do with the failure to report and return no overpayments. And it also expands the application of civil monetary penalties, or CMPs, to any individual or entity who knows of an overpayment and does not report and return it in accordance with the ACA provisions requiring such action. They define overpayment as any funds received or retained under the Medicare or Medicaid program to which the person entity, after applicable reconciliation, is not entitled. And I think it's important to note that not only does there this provision through the ACA which allows for this exclusionary authority, but as a practical matter, the Affordable Care Act and has made the failure to return an overpayment a violation under the False Claims Act, under the reverse false claims provisions. And then, of course, we have the 60-day rule now, and we'll be talking about those later, but all of which is to say, when we talk about this exclusionary authority, and as Tony mentioned, it overlaps, and much of what we're talking about is layered upon other things. So, for example, someone could pursue a criminal False Claims Act claim, civil False Claims Act claim. They could pursue, in tandem, exclusionary powers to exclude the individual from the federal health care programs. Slide 13, please.
Okay.
Basically, OIG's B15 permissive exclusion authority extends to individuals. It's not used that frequently, but it's a type of permissive exclusionary authority that they have that can exclude somebody who has a direct or indirect ownership or control interest in a sanctioned entity and who knows or should know of the action constituting the basis for the sanction, or who is an officer or managing employee of such an entity. And I think what that reflects really is it captures the responsible corporate officer doctrine principles that we discussed before. And Tony, you can skip over slide 14.
Okay.
That simply defines sanctioned entity, which means any entity that's been convicted of any offense under 1320A, those offenses that can lead to a mandatory exclusion, and then convicted of any offenses described in Section 7B1, 2, or 3, which are the first three offenses that can lead to permissive exclusion. Slide 15, please. And when they're talking about permissive exclusion authority, we talk about what a sanctioned entity is and what it means for an individual to should know of information or conduct. And it says an individual should know of information or conduct when the individual acts in deliberate ignorance or reckless disregard of the truth or falsity of the information. And importantly, no proof of specific intent to defraud is required. And again, that parallels what we see in the False Claims Act, where somebody can have the requisite knowledge without having actual knowledge. Reckless disregard and willful ignorance are enough. And I think we're going to see more prosecutions and civil enforcement actions against individuals, both under the Civil False Claims Act and otherwise, for this omission to have acted or knew or should have known. And if you think about should have known, there's a lot of parallels between that and the responsible corporate officer doctrine. Slide 16.
Okay.
So under B15, and Tony, chime in if you think this is wrong, but that's permissive exclusion authority that's been used very infrequently, by my calculation, roughly 30 times or so. And we talked about the B15 permissive exclusionary authority as kind of paralleling the principles from the responsible corporate officer doctrine. And before I turn this over, what is your sense as to whether there will be more 7B15 permissive exclusion authority exercised in the coming years?
Yeah, it's a good question. I think it is an authority that's used a little bit less frequently, and it's really because the statute isn't terribly helpful. Because the way that the statute is worded, you have to have it's worded in the present tense is the best way to describe it. You have to have that ownership or control interest or be a officer at the time that we bring the action. And what we frequently find is that the bad actors have left the company by the time the government's investigation is done, and so we don't really have the B15 authority. We don't have it much of the time. What's used much more often is the B7 authority, which is the permissive exclusion authority for committing an act, the one that you mentioned for committing an act, essentially for engaging in fraud or submitting false claims or violating the kickback statute. And I think that that authority is used a little bit more often, or it at least comes into play more often when you're talking about a settlement context. But I think that B15 is certainly, it's a tool in our toolbox. The facts don't always play out in terms of it being applicable.
Well, one of the things I saw was that there was, I think it was in the fall of 2010, there was new OIG guidance issued that addressed B15, and it said where there's evidence that an officer, owner, or managing employee knew or should have known of the conduct leading to the exclusion or conviction of the entity, the OIG intends to operate with a presumption in favor of exclusion unless significant factors weigh against exclusion. And then they go on to say where there is no such evidence that the person knew or should have known, the OIG will apply several factors. And if you move on to slide 17, we'll just pop those up. And then you can provide your comments on how you think that has worked in practice and is working.
Yeah. I think that the part of the intent behind doing the guidance on the factors was because it is a relatively infrequently used authority, but it is, as the government, is concerned about this cost-benefit analysis problem and looking more closely at individuals, people in the OIG believe that we needed to issue some more clear guidance about how we were going to look at this situation and apply this authority. And I think because in part the managing employee, you don't need to have the knew or should have known, the officer or managing employee, that's not an element necessarily. So we believe that there was a need to provide guidance about what it is how we were going to make this evaluation so that providers could look at themselves, look at their compliance program, to figure out what they needed to do particularly when they're faced with the situation of discovering a problem in their organization, how do they need to respond to it in an appropriate way in order to mitigate and resolve their liability? And I think that perhaps the effect of this guidance was to encourage more people to do that, to take more affirmative action when their compliance program finds a problem. As you say in the last bullet, response to awareness of misconduct is really a paramount factor in this situation.
Okay. Well, thank you. That concludes my segment. And again, apologies for my power outage here. But let's continue on to, I guess, the next, if you can advance, Tony.
Yep.
It's computer use by the government.
Yes, and I'm going to touch on very briefly, as we were planning this call, one of the topics that came up a lot was in our discussion was the government's increasing use of computer data to assist in combating fraud, waste, and abuse. And it was important enough that we felt like we wanted to highlight it here because there really has been a sea change over the last decade in the ability for the government to access and analyze claims data, both to identify investigative targets, but also to more efficiently investigate the Keytown allegations that we receive in the numbers of the hundreds every year. CMS has this ability in terms of changes that have been made within CMS and its contractors, including the zone program integrity contractors and the RACs. The fraud prevention system, or the FPS system that CMS has begun to develop, is a very promising, is certainly a promising aspect in their ability to do predictive data analysis and analyze claims for potential fraud trends. OIG and DOJ also have greater access to this data now than we have had before. Many of our agents and U.S. attorneys' offices can access a certain claims data universe from their desktop, which is really a revolution from where we were a decade ago in terms of being able to get such good real-time and relatively efficient access to the claims data. And I don't know if Linda would like to chime in here from her perspective.
Sure. Thanks, Tony. It is amazing to have the 3 years of data that we have, and it's usually fairly raw data because it's live claims data, so it's not data that's been finally adjudicated. But particularly when you get some information about a provider and you want to just do some checking to see whether or not what you're hearing is accurate, that's what we can use that data for right on our desktop instead of having to wait maybe 30 days or more for a fraud contractor to provide that data to us. So it certainly makes us a lot more efficient.
And one other way in which it becomes relevant too is we'll talk about the OIG self-disclosure protocol later on. And one of the ways in which data is helpful here is that we're able to at least spot check or do some confirmation of what the provider is saying in their self-disclosure in terms of the amount of billings that they have in a particular area. It's sort of a trust but verify situation in a self-disclosure where we are able to do that spot checking much more efficiently, which has helped improve our resolution time for protocol matters as well. It's one of the factors that has gone into that improvement. So if we don't have anything else, we can move over to Linda on the enforcement FCA piece.
Thank you, Tony. The first thing we're going to talk about is the False Claims Act, which Bob has alluded to in his presentation. And this is the statute that was passed during the Civil War period, and it's maintained its vitality over the decades and has really come to the forefront in the last let's say, 25 to 30 years, when it's been used substantially in the area of healthcare fraud. Just so that you know, the citation for this is 31 U.S.C. Section 3729 et sec. That includes the False Claims Act, false claims provision, also the qui tam provision, and also the provisions that have to do with civil investigative demands, which are an investigative tool that we use under the False Claims Act. But basically, the first slide tells you about what kind of actions can bring you under the purview of the False Claims Act. Presenting a false claim for payment or approval, causing someone to present a false claim. So in other words, if you're a physician and you don't actually present the claim to the carrier, the physician is still liable by causing someone in his institution, for example, to submit that false claim. There's also a conspiracy statute in the False Claims Act. If you conspire to defraud the United States with getting a false claim paid. And then finally, the reverse false claim, which is making a false or fraudulent record to not have the government, to have the government pay you money that you shouldn't have gotten, or to have the government pay you more money than you should have gotten. The elements of a False Claims Act case are pretty much what the elements of any fraud case would be. We must have a claim that is submitted. It must be false, and there must be knowledge. Now, knowledge under the False Claims Act is not the same as the mens rea you need for a criminal activity, and we'll talk about that in a little bit more detail shortly. But there must be knowledge, and then there must be materiality. And this is an important one because that means that the falsity that we're talking about must be something that would be material to the payment decision. In other words, would Medicare have paid this claim had they known that this element of the claim that has been submitted is in fact false? And there can be technical issues with a claim that would make it a technical problem, but that doesn't necessarily mean that it would be material to the payment decision. Maybe it would be material for purposes of an overpayment, but it might not be material for purposes of going after someone for fraud. Because you should keep in mind that distinction. Every overpayment is not a False Claims Act case. And the fact that you have made an overpayment, or a RAC decides that you've made an overpayment, or any audit makes that determination, doesn't automatically mean that overpayment would turn into a fraud case. Now, the targets of a False Claims Act can be any person, is what the statute says, but a person is defined very broadly. It can be corporations, partnerships, any kind of association, a non-state government entity, and also a state government entity, although that part of the statute can only be brought by the United States solely and not on behalf of the United States by a whistleblower or a relator. And, of course, individuals can be the target of a False Claims Act as well. One of the things that's I think most terrifying for defendants under the False Claims Act is the damages and penalties provisions, which are pretty severe. The statute talks about mandatory treble damages, which is 3 times the amount of the government's loss, and in addition, a civil penalty of right now between $5,500 to $11,000 for each false claim that has been submitted. So you can see how quickly these numbers can become pretty enormous when you add both the trebling and the penalties. And I might add that not only does the federal government have this False Claims Act statute, many states have similar false claims statutes with almost identical provisions in many instances, which also allow the treble damages and penalties. And there have been courts that have held that if an action is brought under both the federal and the state False Claims Act, it is allowed to assess the civil penalties both on behalf of the United States under the federal statute and for the states under the civil statute for the same false claim.
And I would say that issue comes up a lot when you're talking about Medicaid, which is obviously a jointly funded program by both the federal government and the states. And in the AWP, average wholesale price litigation, and other cases, that was precisely the case, where there was sometimes both state false claims law and federal FCA cases that were pursued. And it gets to be like a three-dimensional game of chess in terms of how the money gets set up, who gets the releases, et cetera.
Yeah, it can be an extremely complicated situation, but it's the level of exposure that defendants are facing that is the reason why so many of these cases end up settling. Because it's rolling the dice at a trial is it can be scary.
And Linda, one question some of the participants may have is, there's also the Criminal False Claims Act, and when the civil FCA was amended a couple of years ago, there were no changes to the Criminal False Claims Act. And traditionally, the government pursues recoveries using the Civil False Claims Act, and criminal FCA enforcement actions are rare. My question for you is, do you see that changing at all, or do you think the government is mostly content to use the civil FCA in pursuing healthcare fraud?
I think for the most part, the reason you don't see it that much on the criminal side is most federal prosecutors, I think, would prefer to charge under the healthcare violation statute, because that one comes with a mandatory exclusion for a felony under that statute. And so I know in my office, most of the time, that's what's going to be the primary charge, and then they might add on additional charges such as mail and wire fraud. But I don't think that it means that there would never be a charge under the False Claims Act. It's just a question of what seems to be the most efficient way of charging this on the criminal side. Now, under the False Claims Act, even if there are no damages, we can still sue for penalties alone. So say, for example, the claim has been submitted but not paid, but we still find out that the claim was submitted, we could still sue for penalties alone, although that is a very rare situation and you don't see that too frequently. If any repayments have been made already, let's say, for example, that a provider has tried to put this through as an overpayment to the contractor, and then there's a subsequent investigation that determines that this was really a False Claims Act case, we would take that into consideration, but what we would do is treble the amount of the single damages, and then we would deduct any repayments that were made via the overpayment route. And this is a holding in the Supreme Court case of United States versus Bornstein, which stands for that proposition that you do the deduction after the trebling rather than before the trebling. Now, there are some, I guess I'd call them, for lack of a better term, safe harbors in the statute. The statute says that if you make a voluntary disclosure of something that is arguably a False Claims Act violation, and you make that disclosure within 30 days of your discovery of the overpayment, and you fully cooperate with the government's investigation, your damages will be capped at doubles rather than trebles. So that's a significant incentive for people who are looking at voluntary disclosure as a way of perhaps solving a problem and avoiding the potential of a treble damage case. And as the last bullet point says, beware the hand in the cookie jar repayments. Again, don't think that you can slide something in as an overpayment and then avoid the possibility that we're going to take a look at it as a False Claims Act case, because all of the contractors, when they receive overpayments, still look at them and make a determination as to whether or not they need to make a referral either to the fraud contractor or someone else to look at the situation presented to determine whether or not there's been fraud. I said earlier we would talk about knowledge under the False Claims Act, and these are the points that you need to remember. You don't need that specific intent, that mens rea, to defraud. That's not required. What you need is actual knowledge, and this gets to sometimes a very legal discussion of this, but I think the easiest way to remember what we're talking about here is reckless disregard of the truth or falsity of the claim that's being submitted, in other words, gross negligence, is sufficient under the False Claims Act, or deliberate ignorance, a decision not to ask the questions where there would be a duty for someone to ask the question. And an easy example I can give is, let's say a physician practitioner who is billing under his provider number, and he hires someone to do his billing who he knows doesn't have a lot of experience in doing any of the billing work, but he nevertheless hires that individual to do his billing. If we find that there have been problems and that there have been issues with the coding that were wrong, things that were coded and upcoded and too high, that could result in a False Claims Act case where we say that the provider who was responsible for the use of his provider number acted with deliberate ignorance of whether or not the claims that were being submitted were accurate when he hired someone who did not have the requisite expertise or knowledge in order to be able to properly code claims and submit those claims. So it's something more than just negligence, but it's something less than the specific intent that you would need for a criminal case. Quitom suits, it's been mentioned a little bit already by Bob and Tony. Quitom suits are whistleblower cases that are brought by private parties on behalf of the United States. And again, the state False Claims Act statutes also have these provisions in them. The private individual, the whistleblower, is called a relator, and the case will be captioned usually United States ex rel, and then the name of the individual who has the information. Any person can be a relator, and just the way a person was defined for purposes of a defendant under the False Claims Act, it's pretty much the same thing for a person under the quitom provision of the statute as well. A corporation, a governmental entity, a nonprofit, a union, any organization or individual who has information about fraud. And my criminal folks in the office usually refer to relators as confidential informants, and that's basically who they are. It's someone who usually is either working for the provider, had worked for the provider, sometimes it's a disgruntled ex-spouse, who has information and brings it to the United States and says, I think there's been fraud committed here. And the incentive for whistleblowers to come forward with this information is that the relator's share of the government's recovery can be as much as 30% of the total recovery that we've been given. The complaint is filed under seal, which means it is not publicly available on the docket. The complaint and any material evidence or information that the relator has must be served on a U.S. Attorney's Office and the Attorney General of the United States, but not on the defendant. And the complaint is kept under seal while the United States investigates. The statute talks about giving us 60 days to investigate the fraud, but as you can well imagine, it usually takes a lot longer for us to investigate the fraud. So we may seek extensions of that seal period to continue the investigation for a showing of good cause. We have to decide whether to intervene or not intervene in the case, and if we do decide to intervene, we take over the case and we litigate it, and the relator may continue to participate. If we decide not to intervene, the relator may nevertheless go forward without us and pursue the action. Now, in practical terms, most of the time when we get to the point of being ready to make a declination decision, we're probably also going to be discussing what we have found with the defendant, because most of these cases settle, and exactly for the reason that we've talked about earlier, the amount of damages that we can recover if we're successful in a case. And just to give you an idea, in the period between 1986 and fiscal year 2012, a total of $35 billion in settlements and judgments were collected under the False Claims Act. And most of that money is actually in the more recent years. For example, fiscal 2012, $4.9 billion was recovered across all of government, but $3 billion of that was healthcare alone. And traditionally, it's about 2/3 of the recovery we get in False Claims Act quitom cases that comes from healthcare fraud. Let me now turn to the next part of the presentation, and that is about government actions on the criminal side. Now, when we do a False Claims Act case and we get, for example, a quitam that's filed here, in most offices, that quitam is not only going to be looked at by the civil side of the U.S. Attorney's Office, but it'll also be reviewed by a criminal health care fraud coordinator in that office to see whether or not the relator's information satisfies what they would need to make a criminal case. The biggest area in which the government, in conjunction with the Department of Justice and HHS, have put together a program to have more criminal cases, particularly in particular areas, has been the Strike Force Initiative, which was formally established in May of 2009. This was a joint effort by the Attorney General and Secretary Sebelius from HHS to try to put together specialized resources in what they called the Healthcare Fraud Prevention and Enforcement Action Team, called HEAT. This was an attempt to focus efforts on fraud in particular local areas where they could hone in on a type of fraud that might be only in a particular area. They started in Miami, Florida, and were wildly successful there in looking at particular kinds of fraud. Mostly it was durable medical equipment and also infusion fraud. And because of those successes, the program has expanded over the past 4 years and is currently operating in 9 different cities across the country. And Chicago, where I am based, is a strike force city. What we have are multi-agency teams that are using a lot of very sophisticated predictive data analysis to determine what the particular type of fraud is in that particular location, and then to put those resources, which means additional investigators, it also means additional assistant United States attorneys and Department of Justice attorneys that will move very quickly to investigate the fraud, to bring the indictments, and then to also look at whether or not they can seize or freeze assets. And part of the reason for this is to come up with a new model instead of the old pay and chase model where Medicaid or Medicare claims are paid, and then years after the fact we go after that fraud and attempt to recover the money, which sometimes can be difficult because sometimes at that point the money is long gone. Now, HEAT has been extremely successful in the time that it's been up and running, which is part of the reason that it has expanded beyond just the initial sites in Miami. And during the time since it's been operative, the HEAT actions in these cities has resulted in a 75% increase in the number of individuals charged with criminal health care fraud. And when I say criminal health care fraud, I'm talking about the specific statute for which a felony requires mandatory exclusion for a 5-year period. And since 2007, 1,400 individuals who had billed the government for $4.8 billion have been charged, which is, truly extraordinary numbers when you compare these numbers also with the amounts of money collected with the False Claims Act. You can realize how much money is involved in health care by the government just by looking at how much has been charged or recovered. The most recent HEAT takedown was in May of this past year, in which the various strike force offices charged 89 individuals for different types of healthcare fraud involving $223 million in false billing. And as time goes on, there's no doubt in my mind that there's going to be more and more of these types of activities in more and more offices, money permitting, so that there will be more of this kind of focused attention in particular areas. And, just as Bob said, that there's more focusing on individuals because of things like the Park Doctrine and other things that OIG is doing. The U.S. Attorney's offices also are looking at individuals and of course, looking at them for criminal activity, which is, I think, even the strongest deterrent that there could possibly be. Let me pass the baton to Tony.
All right. Yeah, and I couldn't agree more, Linda. I think that there have been a number of individual cases or cases brought against individual criminal cases brought against individuals, particularly in heat, but even outside of heat cities, and that but the real deterrent effect that has been, not only you pointed out the recoveries and the numbers associated with individuals charged and the amount of restitution, but the deterrent effect in the heat cities has also been amazing when you look at the claims, the level of claims filed after heat has come to town, if you will, is decreased. There's been a large drop in claims because this sort of visible enforcement effort has created a deterrent effect, which has a monetary value with it as well. So now that hopefully we have scared everybody in terms of our discussion of exclusion, responsible corporate officer doctrine, the False Claims Act, criminal cases, there may be a thought of, well, what do I do to avoid getting into all of this hot water? And one of the biggest ways to avoid getting into this hot water is to have a good compliance program that actively looks for problems in the organization, and when finds them, deals with them appropriately. And from the OIG's perspective, we think that that means self-disclosing the problem to the government and entering into a resolution. And so I want to take a little bit of time to talk about the OIG self-disclosure protocol, which we recently reissued in 2013. And one of the main point behind reissuing the protocol was to provide more transparency to the self-disclosure protocol or SDP process. OIG has had a protocol for about 15 years, and over that time we resolved hundreds of matters, recovered $200 and something million, and believe that, and over time we've also adjusted the process and issued 3 different open letters which changed or clarified different aspects of the protocol, and we believe that there was a need to consolidate that guidance and to make our protocol process more transparent in order to provide even more incentive to self-disclose conduct that people find in their compliance programs. So the point was to set up more clear guidelines and expectations too, so that we could help resolve these matters in a more timely way, and that people had, as all of the lawyers on the phone will attest to, one of the biggest challenges that you have is managing your clients' expectations. When they go to the government, they want to know, well, what is going to happen to me? What is the process? And by having a more clear set of rules of the road up front, our intention behind updating the protocol was to make it more transparent so that you could set your clients' expectations in a more informed way. So to further amplify why we believe why disclosure is important, it has been OIG's long-standing position that participants in the federal healthcare programs have a legal and ethical duty to interact with the program with integrity, and that includes taking measures to investigate and appropriately resolve potential fraud. As I said earlier, that's one of the reasons why the SDP was created, to provide that mechanism to disclose conduct to the OIG. And it is, with a number of people from OIG have said this over time, is that one of the clearest indications that an entity has a robust compliance program is that the program finds problems and takes steps to remedy them, including disclosure to the government when appropriate. However, on the flip side, entities that don't look for problems or who find them and do not properly resolve them risk getting into more trouble under the False Claims Act and the Civil Money Penalties Law, as we've talked about already. There's always a risk that a relator, an ex-employee, a disgruntled former spouse, for instance, or other informant will tell the government that you're not fixing problems, that you found them, that you're not fixing them, and that you owe the government money. So just to go over the benefits, but specifically to the self-disclosure protocol, a couple of new things too that we put in this new version is that we believe we articulated a 1.5 multiplier as being our baseline for resolving these matters under the OIG civil money penalty authorities. And this is generally lower than what the government seeks in an affirmative investigation. Again, we think that this provides a significant financial incentive to disclose, while also recognizing that we're talking about conduct that implicates a fraud law. Also, second, we generally don't require a compliance agreement. It's been our policy for a number of years now, and I think we've resolved roughly 280 disclosures since we articulated that policy in an open letter, and have only required a CIA in one of those cases. So it's a very strong presumption that no compliance agreement is necessary when we are successfully resolving a protocol submission. They also, providers also receive the benefit of a resolution that is often faster than a government investigation. As we've talked about, government investigations can take significant time and resources, both on the part of the government but also on the part of the provider. Being under investigation requires a great deal of time and energy in an organization to respond to subpoenas, to do their own internal investigation, to deal with the government, and you are able to have a different relationship with the government when you are not in that position, but when you are disclosing the conduct affirmatively. You also have the benefit of being seen as more trustworthy and responsible if you're somebody who has self-disclosed. It really does change the dynamic of the conversation, and the ability of and the tenor of the whole interaction is different when you're dealing with somebody, with a provider and with counsel who have said, look, we found this problem, we want to resolve it, this is what we've done to fix it. It's a very different dynamic. And finally, the self-disclosure may address liability under the 60-day rule. CMS said in their proposed rule that the protocol can satisfy the report and return obligations. This isn't a final rule yet. It's still a proposed rule, but the OIG agrees with this approach, and we're hopeful that it will remain the same in the final rule. I'll also add, too, as a practical matter, it would make sense to me that if somebody has properly disclosed conduct to the government, the government would seem to have a hard time arguing that there was some sort of knowing or improper retention of an overpayment. So disclosure would seem to provide some protection, and I think there may be some desire to talk more about the 60-day rule and the benefits of that. But I think that Bob is not on the phone anymore, too. So he.
I am.
Oh, you are?
Yeah.
Oh, okay. You're not listed on our little presenter list anymore. Do you want to jump in here?
Well, what I was going to ask, and I think maybe some of the participants have this question, is, so let's say I'm a provider and I'm doing my own compliance audits, and through the normal course of events, I identify an overpayment. Are you saying that, I still have the potential to just simply report that on an administrative level to CMS that I have identified this overpayment, and I guess the question is that seems like it's kind of level one. Level two is more of the following the SDP protocol, and then level three is when you've identified a bona fide False Claims Act violation for a reverse false claim, perhaps. So I guess my question is for you is, where do you draw the line between this is a garden variety compliance check I've done, I've identified an overpayment, and now I have to decide whether I just address this on an administrative level with CMS or if I need to elevate it to self-disclosure?
Yeah, that's the $64,000 question, I think, in many of these scenarios, is where is the right place to go when you have a problem? And I think you're absolutely right, is that if you're, and the OIG protocol does say this expressly, that if you're issue is an error or merely an overpayment, where you made a mistake in the coding or in the bill, but there's no potential fraud there, you should return that to the contractor. That's not something that is appropriate for the protocol. It's not if there's no potential fraud. So I think that I think it's a very fact-specific analysis that providers then have to do to determine what the cause of what is the problem, what the cause of the problem is, and whether there is potential fraud exposure under a civil money penalty authority or under the False Claims Act. And I think, yes.
Oh, and I would say that I would think another question pressing on people's minds is, at what point can a provider or payer who's done a compliance audit, they've identified an issue, let's say a potential overpayment, at what point have they identified that as an overpayment for purposes of the 60-day clock, in your judgment?
Right. That's another really good question that we don't quite have an answer to yet either, because CMS has to issue their final rule for the Section 1128J, and I think that their proposed rule had a definition of identified. I think they received a lot of comments, and we'll need to address those in a final rule. But if you're asking me from an enforcement perspective, I think that providers need to act in a reasonable manner when they have found an issue and deciding how to deal with it. I think that there's going to be, to the extent that there is an enforcement risk, we're going to see cases involving the 60-day rule and people failing to return identified overpayments. We're probably going to see cases where people behaved like ostriches and stuck their head in the sand and did not, had some information that there was a problem and that did nothing further to look into it, or did a very bad and attempted to cover it up. We're probably not going to see cases where somebody took 65 days to do their investigation and return the overpayment as opposed to 60. I think that there's a real, I think that the people are going to end up being held to some sort of a reasonableness standard by at least enforcement agencies in making those sorts of case decisions.
So let me ask this question to Linda. So as an AUSA reviewing cases for civil FCA enforcement, the FCA, the Reverse False Claims Act provision of the False Claims Act used to read, before it was amended by FARA in 2010, it used to read, in essence, that in order to be liable under the Reverse False Claims provision, someone had to actually submit something or take some affirmative action to be liable. Whereas now, the way the Act is read is that simply wrongfully having an overpayment that you know or should know is an overpayment is enough for liability under the Reverse False Claim provision. And so I guess my question for you is, A, do you agree with that? And B, what is your view of when somebody knew or should have known that they have an overpayment? What is the level of trigger? Is it simply a whistleblower calling on a hotline? Is it being put on notice but then doing your own due diligence or an internal review at an appropriate level to have identified that for purposes of the False Claims Act and also for purposes of the 60-day reporting?
First of all, I do agree with what the statute now says about the reverse false claims, and I think the context in which it most typically would happen is, a compliance officer that says, we're doing this wrong, we've been doing this wrong about how we've been submitting this kind of claim and how we've coded it, and a decision is made only to change the practice going forward and not to pay back anything from the prior bad submissions. That to me would be the perfect example of the reverse false claim. And with regard to when and what constitutes any of this, and let me preface what I say by saying I'm not talking about the SDP that Tony is talking about, which is set forth by regulation. I'm looking at it from the voluntary disclosure provisions of the False Claims Act and situations where I get voluntary disclosures made to the U.S. Attorney's Office here, which happens quite frequently, I must say. And when I get people who come in, attorneys who come in on behalf of a provider with a potential voluntary disclosure, most of the time they're coming to me when they've discovered something. They've discovered enough to think that this could be a problem, but they probably haven't fully quantified it yet, and they want to sit down and talk with us about what's the appropriate way to try to quantify it, how we'd like them to conduct an audit so that they're more certain at the end of the day that when they come up with a calculation based on the audit that we're going to them. And I have to say that personally, this is my opinion, I don't hold fast to the 30-day rule of what the False Claims Act says, because I understand how long it can take from an institutional standpoint to not just find a problem, but get it through the layers of authority, and then maybe to have to go to outside counsel to get their advice as well. Can take longer than that 30-day period. My view is if somebody demonstrates due diligence and they're coming to you as soon as they possibly could under the circumstances, that's sufficient for me, and I would not want to turn someone away who's made a good faith voluntary disclosure just because they're at the 35th day after they found out about it. And just to add, voluntary disclosures that are made to U.S. attorneys' offices, I've never had a problem with Tony's office in getting their approval and okay for a settlement that we enter into that way. And we do need to get their approval because obviously people who make those disclosures want releases from OIG as well. And just as Tony said that under the SDP and under the voluntary disclosure protocol there is now no CIAs that are required typically, the same has been true with voluntary disclosures that have been. And so I think it's a perfect example of all these elements of government working together and nobody being territorial about where we think someone should have or could have made the disclosure. Everybody's treated pretty much the same across the board.
Right. I think that's how we've tried to approach it. It's nice to hear that the government can work together well sometimes. But I think OIG anyways recognizes that providers, their counsel need to make decisions about where to disclose, and the act of disclosing is really the most important thing. Whether somebody goes to the U.S. Attorney's Office or to the OIG protocol, it would be a little form over substance to say, well, you don't get a CIA in the protocol, but we're not going to treat you the same. I mean, that the point of the incentive is to encourage people to have the effective compliance programs that find problems and disclose them. So we do think it's important to treat, we have been treating those situations similarly. Did you want to go? I could just sort of very briefly sort of go through what's eligible and what's not eligible. We've sort of covered what is eligible, the potential violations of federal criminal or civil administrative law for which the MPs are authorized. This is a little bit of a point of contention, at least in terms of acknowledging that there is potential liability. And I think in my experience, most DOJ generally also wants, some acknowledgement that there is potential fraud liability here that we're resolving. We're not resolving just a mistake or an overpayment. And the idea here is that we're also not supposed to be getting into some sort of protracted debate about whether there is a fraud claim here or not. The point of resolving a self-disclosure is not to engage in that sort of debate, but is to there is no admission of liability that is necessary, but I think there needs to be some acknowledgement that there is some exposure that the provider is interested in resolving. And in terms of what's not eligible, we've also covered, I'll also say that CMS has a protocol also for Stark-only conduct that we're not going to talk about much other than to say that it exists for Stark-only conduct. It's not an OIG protocol, it's a CMS protocol. And I think, picking up on what Linda said in terms of resolution, we do coordinate with DOJ on protocol matters, including disclosures that people make directly to U.S. attorneys' offices. There are fraud enforcement partners, and so sometimes they choose to participate in protocol resolutions, and sometimes they choose not to. And it can vary based on the jurisdiction and what their enforcement priorities are and what the case is also about. So that can vary. And
so, Tony, what about the scenario where, let's say I'm a provider and I've identified an overpayment and I want to self-disclose? I go to you and I make the disclosure, and how do I know that? I mean, what's the process you then undergo to determine whether you're going to also then affirmatively reach out and bring an AUSA like Linda into the mix to review it if you think that the overpayment or the facts might warrant potential civil FCA exposure?
Right. No, it's a good question. And what we will do is, in most, generally speaking, is that we'll, at the end of our review of the disclosure, once we've gotten all the information that we're looking for, we'll know what district we're in, and the OSIG attorney and the agent will have a conversation usually about, well, whether this case is something that we need to bring to the U.S. Attorney's Office or not. Certain U.S. Attorney's offices, generally speaking, will know what it is, whether the conduct is something that they would be interested in. Some U.S. Attorney's offices have more of a have a monetary threshold where their cases under a certain amount of money are not going to be something that they're interested in pursuing. But generally, we err on the side of caution, and we'll call up an AUSA like Linda and say, we have this disclosure, this is what it's about, would you want to participate in the resolution?
One of the key things from my perspective, too, is that if a defendant, prospective defendant, wants a fraud release, it's only the Department of Justice that can give them a fraud release.
Right. It can also have, if the provider asks, for a False Claims Act release, well, then we have to, DOJ has to become involved. But we do go through that. We do go through that process with the disclosures, and and if the answer is yes, then they become involved. If the answer is no, they don't. They're going to pass on this one. Then OIG will resolve it through a CMPL or a civil money penalties law settlement.
Well, Tony, Linda, and Bob, thank you. It's now time to move into the question and answer phase of our discussion, and I want to thank everyone for the patience while we sort through our technical difficulties earlier. Mary, would you please give instructions on how the audience should ask questions, please?
If you have a question at this time, please press *1 on your telephone keypad or enter your question in the chat Q&A box on the left side of your screen and press Enter.
All right, our first question is directed to both Tony and Linda, and it's a question about the expansion of the individual doctrine to not only where we've seen it in pharmaceutical companies and DME companies, but also to the settings of health systems and hospitals. Do you foresee examples where the government may pursue individual officers under the Parks Doctrine or under criminal exposures for fraud allegations?
I think yes, and I think it's because, as Bob was saying, There are many repeat offenders, defendants who have not only had one case with the government, but more than one case. And you reach a point of thinking that, well, if a False Claims Act case is not sufficient against the entity, then you have to ratchet up the stakes up to a higher level. And the only other that is to look at individual liability. And I think some recent settlements in this past year, the CIAs have included provisions, for example, that were aimed at individuals, saying that if any of certain identified individuals, and usually identified by their role in the corporation, are found to violate any terms of the settlement or the CIA, that the company will be required to, pull back bonuses or other executive compensation from them. And I think that's, again, part of this whole idea that you have to somehow stop the continuation of the fraud, and going after individuals might be the only way to get people's attention.
And Tony, do you have any thoughts from the OIG perspective about seeking exclusion against officers of hospital or health systems for fraudulent conduct?
Yeah, I think that is something that we look at very closely, particularly in larger cases. But it's also something that we look at very judiciously, because that's a very serious thing to do, to bring an exclusion action against an individual, and so we have done it. We have brought those cases in certain circumstances. We brought a couple of those cases. We haven't brought large numbers of those cases, I think, because we take that very seriously, that's a big decision to make. And we need to have the evidence and to back up making that claim, because if we're going to assert an exclusion claim against an individual, the only real settlement there is some period of exclusion. I mean, as Bob said earlier, exclusion is remedial. It's not about money. It's not about paying a fine in exchange for an exclusion release. It's about it has a remedial effect, and if we're bringing an exclusion case, we believe that person is not trustworthy to continue to participate in the programs. One of the others, as Linda said, one of the ways in which we try to get at that too in a settlement context is in the CIA, because the CIA is done in exchange for the exclusion release for the entity and usually any individuals who are named in the complaint. And one of the other ways, in addition to the clawback provisions that Linda mentioned, would be to have, increasingly we've had more individual certifications in CIAs from board members, from senior management, from even middle management in organizations, to certify that they are personally certifying that what they have responsibility for is in compliance with the CIA and with federal healthcare program requirements. And I think that drills down deeper into having individual accountability within the organization.
And this next question is directed to both Bob, Linda, and Tony. The question, several questions, I'm kind of combining the request, is, as counsel for a system, whether in-house or outside counsel, what are the actions that counsel should take to minimize the possibility of criminal prosecution for a client? Or if there is some sort of allegations of fraud, what steps in this current climate should be taken to minimize the impact?
This is Bob. I'll jump in first. I think as an outside counsel for any plans, payers, and providers and health systems, the first thing you do when you get the call that said, we think we have this issue, is you try to gauge how big it is, how long it's existed, and try to quantify it in terms of what the potential dollar amount is, to assess whether what level of review is required, whether it's an internal review that in-house counsel can do on their own, whether they need outside counsel to come in to protect themselves through having a layer to conduct a review, and that can be a mini review or a full-blown review depending upon the magnitude of the problem. Because the thing to remember in all of this is that when you're looking at compliance, you have to look forward. But when the government gets news of alleged conduct, they're looking backwards. So enforcement is very much retrospective, and they're going to second guess, rightly so, what steps the company took to identify a potential problem, and then to assess a potential problem, and then to do whatever a prudent reporting step might be. Obviously, my view as an outside counsel is you want to look for the least elevated level of disclosure that you can make. So if it is a garden variety error that was through no fault of anyone's, but it was identified as an overpayment, try to handle that at the administrative level as simply a repayment of an overpayment. But again, you have to take a reasonable analysis and assess, okay, is this something that would require something under the self-disclosure program? Or is this actually something where we think there is a real potential FCA violation here, and it's something I need to go and talk to Linda about? And so those are the things that you do. But the benefit to doing that is knowing that either it's Linda or Tony, but they're going to look back and say, okay, what did you know? When did you know it? And what did you do about it? And I think acting prudently is kind of figuring those things out in terms of how big is the problem, what level of review do I need to do, and then to devote the resources to doing it.
Let me just chime in and say that, to me, the best way to avoid seeing the U.S. Attorney's Office, either on the criminal or civil side, is having a strong compliance program and an entity that works at this all the time. Because if you do have things in place to try to find the fraud and deal with it, address questions as they arise from your hotline, it's harder for us to make a case against you either criminally or civilly. So it's the proactive activities of a provider that can many times save them from any kind of litigation with us.
And that's actually a nice lead into our last question for today's presentation, and that is, how does counsel advise a client, which protocol for self-disclosure they should be using, whether they should be going to the contractor, to OIG, or to DOJ?
Well, let me chime in on that one. I usually tell people that they have to think about what is best for them. Some providers and entities have good working relationships with the contractors. Other providers have outside counsel who have good working relationships with U.S. attorneys' offices because their attorneys used to work in the U.S. attorney's office. Others have good working relationships with OIG. And you have to think about this before you have a problem, and you have to be aware of, well, where would it be the best fit for what I've got to report? And U.S. attorneys' offices have websites, so you could see the kind of cases they're doing and how they've handled them. Similarly with OIG, you can see what they are doing and make the decision based on the kind of situation you're presented with and where counsel thinks is the best fit for the client to get the best fair shake they can.
Right. I do think that it is a fact-based analysis, and we're talking about whether and in part it's about assessing the intent or the arguments about intent. Was it a mistake? Was it negligence? Was it gross negligence, which is more like reckless disregard or deliberate ignorance? Where are you in that spectrum? Keeping in mind that the intent of your employees or agents is imputed to you, and I think that's where counsel and where people in the compliance department need to do an objective investigation of the facts and determine sort of where their liability exposure is. And if it is something that can be handled on the contractor level, I think it's appropriate to do that. If it's something that rises to a reckless disregard or deliberate ignorance level, then I think you have a different situation, and you have to figure out whether. And then it can go to relationships or past experience, or which how serious is the conduct in terms of whether you would go to the OIG protocol or the U.S. Attorney's Office. It's a complicated, it's frequently the question that's asked at the end of these sorts of presentations, where do I go? And I think it is many times a judgment call that is very dependent on what your facts tell you, and what your judgment is about what is in the best interest of your client.
Excellent. Well, unfortunately, our time is up for today, but I wanted to thank the audience for joining us this afternoon, and I want to thank you, Bob, Linda, and Tony for participating and giving us the benefit of your advice on these issues.
I would like to thank our speakers for their excellent presentations and you, the participants, for joining this call.